Hello everyone, I am Dr. Kalpana. Today we are going to discuss about law of contract, starting with the introduction of law of contract, the very basic and conceptual understanding about the subject. So law of contract is a basic part of mercantile law and it is the foundation for many other laws which would be referring to it whenever it is needed or when we come across in further lectures. So, the object of law of contract is to ensure that rights and obligations created by contract are honored. The law of contract is mainly concerned with three questions, which are very important to ensure whether this relationship or that kind of nature of right comes under the ambit of law of contract. First question is there any agreement? Because genesis of forming a contract begins with having an agreement, and we would be dealing with the question, what is an agreement, what makes an agreement? Can the parties to such an agreement enforce it in the court of law? Is this agreement enforceable by law? Law imposes an obligation to the party who breaches any promise of agreement. How they can enforce it? What is the procedure? Where is the law? What is the jurisdiction, etc.? That question is also equally important when it comes to breach of contract. So now coming to the very basic and beginning of the subject begins with meaning and definition of anything. So what is the definition of contract? Many of the jurists have attempt to define, and that is the gist of those definitions. So contract is an agreement creating and defining obligations between the parties who have agreed to do something or to abstain from doing something. So the object of law of contract is to ensure the rights and obligations created by contract are honored, and that expectation is actually created by the promises of the party to an agreement are fulfilled, and legal remedies are available to an aggrieved party against the party failing to perform his part of agreement, whoever breaches that agreement or promise to perform or to abstain from doing something. So section 2H of Indian Contract Act defines contract. Very simple in three words. An agreement enforceable by law is contract. So it's not that simple as it sounds. So agreement is what? We need to understand what is agreement. So offer, if someone makes an offer, it is accepted by someone, then it becomes agreement. And contract is agreement plus enforceability at law. So agreement is defined under section 2E of Indian Contract Act. So every promise or every set of promises forming the consideration for each other. So now question is, what is consideration? So we would be dealing in a separate chapter. It is a big topic in law of contract, though for your basic understanding of consideration, for example, if I want to sell one mobile and I'm making an offer to be, I want to sell my mobile for 10,000 rupees, then he accept that offer and price, then this is an agreement and it is enforceable by law. That 10,000 rupees are basically consideration in law, because he would be getting mobile and I would be getting 10,000 rupees. So that 10,000 rupees is basically consideration here. So agreement is defined under section 2E. So every promise or every set of promise forming the consideration for each other is an agreement. So a promise defined under section 2B of Indian Contract Act, a proposal becomes promise when it is accepted. So if someone promised to do something or abstain from doing something and someone accepts the same, it becomes promise. And every set of promise or forming consideration for each other is agreement. The very important and interesting aspect of law of contract is every promise or every set of promise, even there is a consideration involved, cannot make it enforceable agreement. For example, social agreement are not enforceable, or any promise which was made out of thrill, excitement, or anything where there was no seriousness to create a legal relationship which forms a contract. So, for example, an agreement to become a contract must create a legal relationship. It should not be purely social, domestic, or personal relationship. For example, A invited B for a dinner, but B could not reach due to some engagement, and A prepared a lot and spent good money on it. Do you think A can file a suit against B for not coming and not performing his promise to come on dinner? No, it was a social promise, so somehow he could not um, reach. So A does not have any right to file a suit against B, not being not having any intent to create a legal relationship which can be called contractual in nature. So there is one very famous case, Welfare versus Welfare, is leading case on this point. Plaintiff and defendant were married couple, and defendant husband and plaintiff wife lived in Ceylon, where defendant worked. In 1915, while defendant was on leave, couple returned to England. But when it was time to return to Ceylon, plaintiff was advised not to return because of her health. Prior to the defendant returning, he promised to send £30 per month as a support to his wife. So parties' relationship deteriorated as party began living apart. Something went wrong in their marriage, and husband stopped sending that money. So plaintiff brings a suit to enforce defendant's promise to pay £30 per month. So issue was whether wife is entitled to bring a suit or that suit is maintainable. So court held that since it is a domestic promise and it is something going on between husband and wife, doesn't seem husband wanted to create any legal relationship, so it doesn't come within the definition or ambit of contractual relationship. So her claim was dismissed by the court. So now question is obligation in a contract. So obligation is defined as vinculum juris, which means the bond of legal necessity which binds together two or more determinate individuals. So therefore, in a contract, there are two parties minimum, because one cannot be agree with himself. So there is a requirement at least two parties or two persons or more people. So one party is under obligation and other party is entitled to enforce that obligation. So if someone makes a promise, other gets an entitlement when it is accepted. So obligation must in respect of doing or abstaining from doing definite act. So most of the people understand that when I promise to do something, it becomes a promise, and if it is accepted by, then mutually it becomes an agreement. But there are promises where people promise not to do something, that is called abstaining from doing a definite act. So obligation must create legal entitlement, no social promises. So there are several agreements which do not give rise to legal obligations and therefore are not contract. Similarly, certain obligations do not necessarily spring from agreements but are enforceable by law. For instance, tort or civil wrong, where people can file the suit uh, for violation of their legal right, which is for unliquidated damages. But in contract, if damages are there, These are the definite damages which can be called liquidated damages. Quasi-contract. Quasi-contract is a separate chapter in law of contract, which we would be discussing sometime later under the chapter of kinds of contract. So here I would be speaking a little on it. So for example, if there is no mutual agreement expressly, but for example, supply of necessities to a minor when it has been accepted. So it is forming a kind of, an obligation on the part of to that partly a contractual finder of goods where he does not know whose goods have been found by him, but he doesn't have any entitlement on these goods. He is under duty to return those goods to find that uh, to whom these goods belong. So decrees by the court, if there is any decree passed by the court, that is enforceable for sure, but may not be contractual right. So what kind of right is this so far as when it comes to having an obligation or right in contract? It is called right in personam, means it is a personal right. So law of contract creates right in personam. It is distinguished from right in rem. So right in rem is available against the whole world. Right in personam is against a particular person who has uh, promised to do something or uh, has promised not to do something or abstain for doing something. So right in rem is against the whole world, right in personam against the person. Now coming the most important aspect of law of contract when it comes to analyzing an agreement and whether it is supposed to be proceeding towards to forming a valid contract. So all agreements are not contract. Only agreement which are enforceable by law is contract. So according to section 10 of Indian Contract Act, all agreements are contract if they are made by free consent of the party. We would be dealing that it is a separate chapter of free consent. What is free consent? Competent to contract means they are having capacity to enter into a valid agreement. For a lawful consideration, consideration is altogether a different chapter. So with lawful object, what are lawful object? I would be discussing with you in a separate lecture, are not hereby expressly declared to be void. So now I'm breaking this section into parts for your easy understanding. So explaining it further, essential element which make an agreement a valid contract. First thing, there must be an offer by someone and the offer should be accepted and it becomes a promise. Intention to create a legal relationship means there must be seriousness on both the sides to enter into that agreement and creating a legal bond or legal relationship. Lawful consideration means the transaction should be lawful. It should not be prohibited by law. Capacity of the party, there are certain people who are disqualified by law to enter into an agreement or to form a contract. For example, minor is disqualified by law, minor's contract is void ab initio, or a person who is of unsound mind, etc. So we will be dealing that incapacity and capacity to contract is a altogether a different detailed course. Free consent. So free consent means here the consent when both the parties are mutually agreeing on the same in the same sense, that is called consensus ad idem, and the contract is being signed or agreement is being done for lawful object. Meaning thereby if object is unlawful, then it can be challenged for its validity and it would not be enforceable. There are some important cases to be studied under this head so far as understanding the basics of law of contract. In Weeks versus Tybalt, that's a case is coming from 1604. Defendant publicly declared he would give £100. At that time, I believe £100 must have been a quite good amount to any suitable man who would marry his daughter with his consent. The plaintiff claimed and he married defendant's daughter and sued for money. Do you think his claim is maintainable? Because such kind of announcement and promises are uh, uh, not seems to be very serious kind of, or do not proceed towards creating a legal relationship. However, the court held his words were not meant to be taken seriously and did not constitute a legally binding promise. The court noted that it would not be reasonable to hold the defendant for journal word spoken to excite suitors. So this case illustrates how exaggerated or vague promises, especially when made in non-serious contexts, do not create enforceable obligation. There's one more case, you can read it, of similar kind, Rose and Frank versus Crompton Brothers. So I have put some questions here which can be answered by going through this lecture, which can help you to understand what kind of question can be framed out of this material. So what is an agreement? I have discussed with you. How does agreement come into existence? What is the process? How does it begin, like promise, acceptance? Are all agreement contract? We have to check the validity under essential elements of valid contract. Not all agreements are enforceable by law. Why? So thank you so much. Have a good day. Take care.